Need
if I could
no,
explain.
no, you don't need to know the sections. Number one, you don't need to know the name of the case.
Oh,
I
well,
just
You don't
need
but
to,
first,
I need to be able to explain what is going on and what's the direction to head.
right. You don't have to remember that the name, the plaintiff was Mary and the defendant was Sam. No.
I just need to know the facts, as in if
Right.
somebody wants to like vote out a director, I just need to know that the information is in an article. We have to
Mhm.
amend it, or whoever have to vote and whatever.
Right.
Okay.
Yeah. It's not required for you to remember none of that. But let's just say if the scenario is similar to one that you read before or one we would have discussed, then you could just say in a case that's discussed in class, this is similar to when the man did this or the company did that. So
Yes.
that's it.
yes. Okay, I understand.
Yeah. You don't have to hurt your head up with all of that kind of stuff. That's too much.
Well, in that case, with them multiple choice for.
Ah, you all asked for it.
No, we ain't need that.
yes,
I know.
God, please, we need that.
No, Carolyn, listen, Carolyn. You're gonna remember exactly what's going on. Because I know you work in the same field right now.
No, but the multiple choice actually juggles your memory. It helps you to remember. I mean, I feel that is the advantage.
But don't forget now, next week, when we finish doing liquidation, if you just do scenario, I would just tell you what are the 5 or maybe what are the 8 or 9 on the exam. And if you only doing scenarios and you have to pick 5, you could pick your 5 after the class is over. Okay, I like this subject, I like that subject, I like that subject, and you could go from there. But they have mother ain't that easy.
Okay, so 1 second. So that the scenarios are from the topics in the book and not cases, correct?
From both. If it's from case, I will tell you.
Mm-hmm.
I will actually give you the name of the case.
Mm-hmm.
I'm not gonna give you a question that relates to a case and you don't know which case it is. I don't expect you to spend your time studying 5 cases along with the book. No.
No.
I would
Okay.
I don't know.
Nothing.
I'm just gonna wing it.
What that means, wing it.
Means read the book with an understanding, not to remember what I read, but to understand what I read. So when I get in the exam, I have a clear understanding of what's going on. So even if the multiple choice were to come around, I'd still know the 2 types of shares or whatever.
No,
Okay.
multiple don't be that simple.
Well, Jesus, how the multiple choice be? Multiple choice is true or false.
No.
A, B, C, D, E, F, G.
Yeah, but it ain't true and false. Don't forget the answers are always very close.
Yeah. So this is a take-home exam, right, Ms. Archer?
No.
Wait, hold on. We have to come in?
Yes.
Oh.
You're in the classroom for 3 hours.
Oh, Lord.
For 3 hours?
Well, you don't have to be there that long.
And this is open book too, right?
No.
Whoa.
Jokey things. That's why I'm telling you, if you do scenario questions, to me, I find students find that easier. They write more and they get better grades. But that's me. If you want,
so how much scenario question is it, Bina? How much scenario?
5.
Child, Carolyn, I think we need to go to scenario, child.
Lord.
One wrong word in that multiple choice, and that's wrong. At least you will know something.
Well, don't forget the scenarios. You've got to know to be able to write, like.
But you'll know. I'll tell you next week what the questions are on.
Okay, that's fair.
Yeah, so
Not-
we'll be able to redirect and shares and liquidation or whatever. So we'll be ready.
So if I say, if I give you a question on this section right now, company compliance, I don't know how I'll word it, but let's say I give you a question on that. I will tell you something like, you work for an FCSP and you've been, and you and your supervisors ask you to prepare a presentation on the reporting requirements for an IBC. Prepare a checklist. So if I tell you that as a review, what are you going to go home and do? If you want to choose that question,
Go over the checklist and make sure you got that down pack in your brain.
okay? And so you walk into exam like some of my students and they could riddle that off. Whether that was 10 or 15 items, let's just say, they could regurgitate all of that.
Carolyn, I think we need to go to questions.
Mm.
Oh, no guessing, sitting there and rubbing out and quibbling out. No. But it's up to you. But I can tell you from what I see from examination, a lot of students always ask for multiple choice. And they're not too happy afterwards, but then they keep asking for multiple choice.
Yeah, we don't want no multiple choice.
I think if you can sit down and write, and let's just say you decide after you finish the exam, you look at it and something clicks to you, you remember. You can put a star, ask for another sheet of paper if you need it, and write again. So when I read it and I go back and I see you have a star, I say, oh, okay. They got confused, but oh God, the light came on. But in multiple choices, right or wrong, I just go down. A,
agree.
B, C, D. The answer is A, B, F, G. That's it. Right, wrong, add them up.
I agree.
That's it.
Christine.
Yeah.
Carolyn, I mean. Carolyn.
Oh,
Mhm.
I think you could write until your answer turn from wrong to right.
exactly.
Yeah, like I said, you gotta know the topic, you gotta be really familiar with the topic to be able to.
Yeah, but she's gonna tell us
And
the
that's
topic,
fine,
so we have no
that's
other choice
fine.
but to know it.
That's fine. That's fine.
But I know some people aren't on, so I will still put the 20 multiple choice, but it's up to you. If you just want to answer your 5 essay, it's
Okay,
up
the
to you.
multiple choice will be a choice. So if you look at it and you're like, this ain't it, just leave that alone and just answer the questions.
Yes.
Yes, I'm with that.
Since
Okay.
everybody isn't on, I think it'd be just to cover them. I put 20 multiple choice.
Mhm.
Yeah. But that's just me and writing exams and students answering. I find the scenarios are better if you study. And if I tell you what it is, I still don't see why you can't get even if you get confused or you forget, you can't get the minimum of 70 to pass. But most students, I can tell when they've studied, they'll get anywhere from 83 to like 94.
Mm.
So you can't study the night before, you know that,
No.
right? But students do very well, I think, on the scenario questions.
And we're still on target for the 15th, right? For the final.
Yes, ma'am.
So no classes on the 1st and the 8th.
No.
Okay,
Next
so we have some time
Saturday.
to study.
Yeah, next Saturday is our last. So you have
Okay.
plenty of time to study and to practice your questions.
Mm-hmm.
So that's what I'm saying. If you decide you're doing 5 scenario, after I've told you what's on coming, you write it down and you decide that, okay, out of all of these, when you review your notes, I prefer to write this. I can remember this better. You have sufficient time to know that stuff.
Mm-hmm.
So I leave that up to you all. All right. So, company compliance. You did read the chapter, right?
I did.
Okay, all right. What jumped out at you? Why this is so important? Company compliance.
Because some clients may try to use our services to launder funds.
Yes.
So we need to get their information straight because they'll try to do it like they tried to launder in the Bahamas while living in Brazil or something.
Right. So from the notes, the introduction, what I wrote, it's critical for compliance, company compliance. And as I've said here, a person comes in and they want a service to operate a company. And what you have to look at is, yes, they're going to come in, they're going to give you their information, who they are, their passport, proof of address. But there are other services that we offer, which is the nominee services. So they don't mind telling you the beneficial owner. But on record, their name will not be there. And remember now, if they're coming just to incorporate a company and to ask for nominee services, you will have no clue once they have that company, what they are doing with the company. Because yes, when they fill out the form, they may say this is for holding assets, or this is for act as an intermediary between companies within a group structure. What does that mean? You have no clue of what's going to happen. So even though they own the company, remember that they realize too that a company is a separate legal entity. And that's why they are always incorporating companies, and they do multiple companies depending on the nature of their transaction. So we all know under the IBC Act versus the CAC that there are different requirements for compliance. The IBC is much more compared to the CAC. So if you look at the IBC requirements, it's just simply that you must have a registered agent, registered office, and that agent office must maintain the register of directors and officers, that you have to file it with the registrar. You can request a certificate of good standing. You know, you can be struck off and you could be restored to the register. But other than that, that's it for an IBC. For a CAC, of course, there's more requirements because you have the annual return that has to be completed. You have the under section 59, the declaration of beneficial ownership. You have the maintenance of the registered office and the documents that must be there, the memo and arts, the minutes and resolution of the shareholders, any notices. The name has to be displayed. And you also know that the register can remove a CAC from the register of companies. But added to that are the CESRA reporting and the register of beneficial ownership. Who can tell me about the CESRA reporting? What is the requirements there?
I'm trying to remember. I did CESRA last year. No, year before last. I know they asked for shareholders, directors, registered offices, address. They asked for company, the registered number. Did they ask for BO? I can't remember. I know they ask for jurisdiction.
Yes, but before you go to all of that, why, what is CESRA?
I remember.
You don't remember?
I didn't have to do it anymore.
Oh, that's why. Who knows what CESRA is all about?
I've heard about it, but I don't really deal with it neither because like that usually falls under a unit that
Mhm.
actually does the reporting for it, like a regulatory unit. So I'm not that familiar, but I've heard about it too.
Mm.
Mhm.
So who's going to say something just now? I thought I heard someone start.
But I
Okay,
know that it's actually an annual report that's done, right?
yes, it's annual, it's done annually. But
Mhm.
remember, this was a global requirement. This is a requirement. Making sure that companies that have different income streams, and you're in a jurisdiction like the Bahamas, you have to be able to substantiate why you're in this low tax jurisdiction. So in order for us to maintain our reputation, because don't forget now, they were saying that all of these big companies are coming here so they don't have to pay any taxes because we do not have corporate tax. So they had to pass this legislation to show to the world that companies that are here, that have income stream from activities based here, they will report those. So CESRA applies to an IBC, CAC, partnerships, and exempted limited partnerships. It doesn't apply to trusts or to NPOs or to sole proprietorship or persons who doing trading as. Nor does it apply to collective investment vehicles. So what's required for the reporting under CESRA is all entities has to submit their annual substance report. And they have to do that within 9 months of the financial year. And like you were saying, you have to have a TIN or an EIN. That's an entity identification number. And of course, you have to register at the government portal. So for CESRA, it depends on whether or not you are what they call an included or non-included entity. So included entities are entities that I guess engage in relevant activities according to the Act. So if you are an included entity and you have relevant activities, then you have to demonstrate economic substance. Everybody got those three things?
No.
No? All right. So you know why we have CESRA, right? You understand that part of it?
Yes, ma'am.
Okay, right. So now when it comes to reporting, I've already told you who it applies to. A CAC, an IBC, a partnership act. It applies to the Partnership Limited Liability Act or the Exempted Limited Partnership Act. And it doesn't apply to sole proprietorship, trading as companies, NPOs, law firms, trusts, collective investment vehicles. It doesn't apply to those. Now, in order to report, you have included entities and non-included entities. Included entities have to engage in what they call relevant activities, and they have to demonstrate economic substance. Because remember, CESRA is all about economic substance. So what is relevant activities? So to be an included entity, you have to be engaged in relevant activities, and that is insurance business, fund business, financing and leasing, banking business. You could be a holding company, a shipping business, distribution business, headquarters business. Those are what they call relevant activities. Now, to be included, again, you have to be engaged in one of those relevant activities, which is banking, insurance, distribution, shipping, intellectual property, fund management, financing, leasing, holding company. But you also have to have an economic substance. An economic substance, you have to demonstrate that. And that is based on the direct, if it is directed and managed in the Bahamas. Remember when we did chapter 1, what did we say about a company? When we did those cases, we spoke about the directing mind and will. So here, economic substance, you have to demonstrate the direct, that is directed and managed here in the Bahamas. 2, that it has adequate qualified employees employed at the level of the activity of the entity here in the Bahamas. Third thing is you have to have the adequate expenditure based upon the nature of the activities here in the Bahamas and the employees. And then the fourth thing is you have to have physical presence. So economic substance means that you must have those 4 features, and you have to demonstrate that. So all included entities have to prove economic substance and their relevant activities. So there are persons who are excluded, and that would be an entity that is 100% owned by a natural person who is ordinarily resident and domiciled in the Bahamas. So that means that you're exempted if you are a Bahamian, a citizen of the Bahamas, or you have a certificate of annual or permanent residency, and you reside in the Bahamas for no less than 3 months. Or if you are an entity that is managed and controlled outside of the Bahamas, and your tax resident is outside of the Bahamas. So now you see when persons come to incorporate companies, what's one of the first things you see when you ask them for their ID? What do they pull out? What do they present?
Passport.
Uh-huh. And what else?
In like their national ID for their specific country.
And come on now, you got to think like them.
NIB?
No.
You think in terms of IDs or just in general?
No, this is in terms of, I wouldn't call it an ID. What do they do? Come on, you have to think like them. I just finished telling you what's required, who are exempted. What do they do? This is,
They show proof of residency.
yes. So the first thing they do on their first point of entry is they're going to try and get their permanent residency.
You are
And now
correct.
you see, right. Remember, I started off by saying that in this business of financial corporate services, there are vulnerabilities to the products and services that we offer. So not just looking at what we offer as FCSPs, but what we offer as a jurisdiction. And people sit down and they study ways in which they could circumvent certain things. There's nothing illegal with you applying for residency. But if I know I can apply and stay here for more than 3 months, then I qualify for being exempted from this filing. So non-included entities are passive holding companies. And what they have to do is they have to demonstrate that they're in good standing. So that all it means is they have to provide evidence that they paid their fees. So if you are an included entity, which means that you have to file, then you have to have an account in the government's portal. Because remember, you could either have a TIN or an EIN. And you have to provide your financial statements that demonstrate your gross income. You have to give information on your employees, the qualification of your directors and your employees, any outsourcing. What else? I think that's about it. And of course, there are penalties. If you commit an offense, under the CESRA legislation, the fine is $150,000. And each day that you don't pay, each day that the offense continues, it's $1,000. And if you don't pay the 150,000, then that's another fee of $1,000. So that says wrong. Any questions? No?
Is there a section on that in our
No,
booklet?
no, I'm gonna send it
Oh,
to you.
okay. Yeah,
I'm gonna
okay.
send it to you.
Thanks. Okay.
Yeah,
I'd like to read
And-
up.
okay. And then the next one is on, the next act is to register beneficial ownership. I know you know that one, right? Yes, no?
Somewhat.
Okay. So tell me what you know about it.
Well,
Why
again,
did it come
doesn't
about?
fall under my purview, but I believe it's also a government portal where the shareholders of any entity are declared, and I believe that's done annually. And it's also connected to the AOG's office. Sorry, our Office of the Attorney General, and it's of confidential nature.
Yes,
means that it's not available for viewing or access by just any ordinary person.
right. So the persons who have access to that confidential information are the Office of the Attorney General, the Financial Intelligence Unit, the
Mhm,
Central Bank of the Bahamas, the Securities Commission, and the Compliance Commission.
mhm.
They're the only persons who have access to that database.
Right.
Right. So that legislation again was from international pressure. Because remember, some countries, even up to I think a month ago, a month and a half ago, the FATF, along with other tax parties or communities, are still lobbying for this register of beneficial ownership to be made public. They're still lobbying for that. They want it done around the world. Some jurisdictions have already voiced their opinion that you cannot let that happen because some of these persons are very wealthy and people will target them. So you're looking at people who will have threats against their life when persons know how much they're actually worth. So you're talking about a person's safety. So we took the route that we would keep our information confidential, and there's a lot of pushback from that because of course we're also a low tax jurisdiction. So the quest is to push for jurisdictions like the Bahamas to have a public register because they want to know who has funds here, in particular with regard to trusts. So the beneficial ownership is for the natural person owning more than 10% or more of the shares or the voting rights in a company. Or it could be a person who exercises control over the management of the company. Now, there are exempted persons or entities from the obligation to identify who is the beneficial owner. And that would be entities that are listed on the stock exchange, or they are licensees under the central bank or the Securities Commission or the Insurance Commission, or it could be an FCSP. And their subsidiaries or their affiliates are also exempted. And an entity that is a foreign, like has a foreign regulated person, they are also exempted. So for BOSS, which is the portal, the information you upload would be the full legal name and any alternate names that they have, when it was incorporated, if it is the incorporation number, when it was incorporated, the status, its registered address, if it is an exempt entity, you provide again the full legal name, the residential address, the country where is ordinarily resident or domicile, the date of birth, your nationality. If you are a registrable legal entity, again, full legal name, incorporation number, date of incorporation, status, and any other information that they request. And that's just about it. So it's not that much information if you compare that to CESRA. Because CESRA is a little bit more technical. So that's it for reporting. I can't think of Anything else? You report to the Registrar General, and then you have these two portals. Anything I forgot?
I don't think so.
No, I think that's it. But I'll send you all just some notes on Cesra and BOSS. Because if I do a question on this, it would include both those Cesra and BOSS along with what's required by the Registrar General.
Okay.
Okay, now before we go, I wanted to send you all a case that I think you all will find quite interesting. Because I don't think did I mention a case of Tal Nemza and V Yusufon and ZRK Limited last week?
I think so.
I did, right?
I think the ZRK one sound familiar.
Sorry, I was out last week, Ms. Wilson. I had an unexpected event, so I was
Okay.
unable to attend.
All right, but you remember when we discussed last week about Bay Street?
Which one was that?
When we spoke about Bay Street and the stores on Bay Street.
I don't remember that. When I was in class listening. The only thing I remember is the cheating man. Well, the man was cheating, right? But
I am so trying to follow that.
Which
Bay
one?
Street issue.
This is what I'm talking about now. I have the case. I want to send it to you all. I have the case. And I said, let me make sure, because I know we had discussed it. So I said, I want to send it to you all because it makes a very good exam question. Because remember, they had agreed, the foreigners had agreed with the Bahamians, and the Bahamians said yes, that they would make sure that all of the regulatory approvals were done. You remember we discussed that last week? No one remembers that?
I wasn't there, so
I was there and I do not remember Bay Street.
Okay.
I only
So,
saw in the news. This is a case in the news now. The matter in the news with the fraud companies or stores, merchants on Bay Street. Same thing?
yes, yes.
Okay. That's why I heard about it.
Okay, so I'm going to send you this case. So in this case, the plaintiffs, let me make it easier for you. Let me just call the plaintiffs Nemza, but it's two gentlemen. So it's these two gentlemen, and they are suing this company called ZRK Limited. And they're suing them for breach of management agreement and negligence in the performance of the agreement. So this happened around August 2016. And Nemza entered into a management agreement with ZRK. The management agreement was supposed to allow Nemza to manage and operate cosmetics, beauty supplies business from the property that they leased from ZRK. You remember these stores now, right? On Bay Street that sells cosmetics and beauty supplies.
Yes.
And the agreement was for 5 years on Bay Street. So the management agreement between NEMSA and ZRK said that they were going to be in the business of selling beauty products and managing the operation of such businesses. And the operators are knowledgeable and they have extensive experience in the management and operation of businesses engaged in the sale of beauty products and services. And they say they're going to manage and promote the sale of the beauty products under the terms hereof, utilizing the name and trading as Truffore Lioness. So they go through all of the, I guess, the key elements of the contract that they had with ZRK. So NEMSA pleaded that they paid ZRK a security deposit along with the first and last month's rent towards the lease of the Bay Street property. And in addition to the monthly rental, NEMSA's aware that they spent additional funds to renovate and outfit the property in order to carry on business from the property. They say that they don't owe ZRK any money. One of the directors of ZRK breached the management agreement by serving an eviction letter with immediate effect on them on March 15, 2017. They say that NEMSA was operating contrary to the laws of the Bahamas, and as such, they were compelled to end the business relationship with NEMSA. So the letter of the 15th of March said this: read ZRK Limited. As I've indicated to you in the past via email and text and in person, I am extremely unhappy about the way that ZRK is being managed. To date, since you have opened, you have not collected any taxes for the government, which you are required to do so on behalf of the company, as stated in our management agreement and Bahamian law. As per communication sent to you on December 20th, 2016, and January 18th, 2017, and February 22nd, 2017, you have failed to collect VAT, which is a breach of the Value Added Tax Act. We note that you have failed to cure these breaches. You are operating a second location without a business license. Now, this is ZRK writing to NEMSA's now, which is once again against the law. This is a breach of the Business License Act. Since the store's opening, you have not cured this breach. You consistently fly employees into the Bahamas to work without the proper work permit or authorizations. Your excuse is that you will get permits later. However, this is again against the law. This is a violation of the Immigration Act. Only yesterday, I walked by your store and noticed a new foreign employee working. I asked your manager if she had a work permit, and he responded that she did not, but she will have one in the future. You have not produced any monthly reports as agreed in our management agreement. You currently have no or maybe one Bahamian working in your stores. I've instructed both of you that according to our immigration regulations, you are supposed to be training and employing Bahamians. It has come to my attention that both of you do not have approval to work in the Bahamas, much less have the right to manage a company here. This is both highly illegal and unethical. As I indicated in previous mails to you and communication with your manager, Guy, that I no longer have any interest in continuing this business, and I am immediately closing all bank accounts. As of your receipt of this letter, I'm giving you notice to cease operations immediately as you are operating illegally. As such, I'm giving you notice to evict the premises within 30 days, given that you have had an excess of 70 days to cure these breaches. Regards, John Scandalaris. Any comments?
They hang on long.
Okay, so the NEMSAs wrote back. They said in their statement of claim to the court, by letter dated the 15th of March, that's the one I just read, Mr. John Scandalaris, a director of, what's the company name again? ZRK, wrote to us terminating the agreement with immediate effect in breach of the terms of the agreement, which allowed the NEMSAs 30 days to remedy any breach. According to the said letter, the reason for the termination was due to the NEMSAs failing to apply for and collect VAT, which is an obligation that the NEMSAs could not perform due to the negligence of ZRK and or its directors failing to provide the VAT certificate after assuming responsibility for doing so. That due to ZRK's breach of contract and or negligence, the NEMSAs have suffered loss and damages. So they say that they had suffered loss of income under the management agreement for the remainder of the 5-year period. They have loss of funds belonging to them, totaling $60,000 that was in their account at First Caribbean. Loss of half of the last month's rent and security deposit, $36,000, and loss of fixtures valued at $100,000. So ZRK then put in their counterclaim saying that the plaintiffs employed persons in breach of the agreement who did not have work permits, saying that they were in breach to obtain the central bank and the investment authority approvals. And what else they said? They say they have no knowledge of what sums of money, if any, the NEMSAs may have expended on the outfit. The $100,000, remember, he said that they had outfitted the space. They say they're not aware of that. They deny that the plaintiff is owed any money under the agreement. And they say that further that ZRK's bankers, First Caribbean, refused to allow the NEMSAs to act as signatories as they did not have regulatory approval. So, counterclaim again, by reason of the matters pleaded above, the defendant's counterclaims for any and all loss attributed to it by virtue of the plaintiff's actions and breaches, specifically failing to get approval from the central bank or the Bahamas Investment Authority, failure to obtain any and all necessary work permits to enable them to work in the Bahamas, knowingly employing illegal workers to work from ZRK's premises, failing to collect VAT or obtain the necessary VAT certificate, failure to pay NIB for themselves or their employees, failure to pay business license or contributions, committing various frauds on several government agencies by reason of the above, breaching the terms of the agreement and the lease, causing the defendant's loss of revenue and rental income. Any comments so far?
No, ma'am.
Okay, so let's see how the Scandalaris met these people. NEMSA is an American citizen who resides in the state of Florida, says that it was ZRK that owned the cosmetic business carried out from the Bay Street property. He says he managed the business along with Yosefon under the management agreement with ZRK. According to NEMSA, it was agreed that he and Yosefon would be responsible for the renovations and furnishings of the storefront and payment of rent. However, notwithstanding their compliance with the management agreement, ZRK terminated for breach, just giving them 30 days. So in 2015, while on holiday in the Bahamas, Yosefon says he met Antonius, John, and Emmanuel Scandalaris. He also deposed that in August 2016, he and NEMSA executed the management agreement with ZRK that was intended to allow them to operate ZRK's limited trading as Trufori. He says the equipment used in the business was still in the possession of ZRK, and it was allowing another entity who was running a skincare business to utilize it from the Bay Street property. He said one of ZRK's directors, Emmanuel Scandalaris, had assumed responsibility for obtaining all regulatory approval necessary for him and Yosefon to operate the cosmetic business. On the cross-examination, NEMSA told the court that there was a franchise a sub-franchise, and investment agreements between the parties. Counsel for ZRK questioned him as to why the various agreements he spoke of were not produced. In answer, he says he probably had the agreements, but could not confirm whether they were executed or not. He also advised that the cosmetic business had very little cash sales. So John Scandalaris, he testified on behalf of ZRK, and he told the court that he and his father, George, were approached by Yusufan and Nemsa in early 2015. He agreed to put the business in his name, knowing that Nemsa and Yusufan were not yet approved to open their own business by the Bahamas Investment Authority. He orally agreed to do this for a fee of $5,000 per month, but he was not paid. He also says that ZRK is not an IBC. He said Yusufan and Nemsa were unwilling to pay fees to the attorneys with whom they had consulted as to what was necessary to obtain a business license. So according to Scandalaris, Nemsa and Yusufan went ahead, opened the cosmetic store without the proper license and only a piece of paper saying that they had applied for a license. To his knowledge, they also did not register for VAT or get a VAT exemption for tourist sales, even after a business license was obtained. Scandalaris says that he also believed that only 2 of the 10 foreign employees who were brought in by the plaintiffs to work in the cosmetic business possessed work permits. Further, they say that Nemsa and Yusufan was sending money to bank accounts of which ZRK had no knowledge. Any comments yet?
I'm just trying to keep up.
Reading too fast?
I'm not reading fast. I'm trying to keep up with the information as it comes.
Okay, so the judge says the principle in this case is whether the contract is void for illegality. He said it is a long-standing common law principle that, quote, no court will lend its aid to a man who founds his cause of action upon an immoral or an illegal act. End quote. The traditional result of the principle was that the court would let the loss lie where it falls. So ZRK submits that the Nemsa and Yusufan camouflaged themselves as a Bahamian company. They had already sought advice from local law chambers with regard to doing business in the Bahamas, advice that they did not heed. Notwithstanding this, counsel for ZRK submits that the directors of ZRK did not execute the agreement relied on by Nemsa and Yusufan. Attention is also drawn to clause 1, which says that Nemsa and Yusufan are entitled to 100% of the profits from the cosmetic business. ZRK acknowledges that it served notice on Nemsa and Yusufan in the letter dated the 15th of March, 2017, where they terminated the lease for the Bay Street property. They say it was intended that John Scandalaris and Manoli Scandalaris were to be shareholders in the cosmetic business as Bahamians, along with Nemsa and Yusufan. However, this did not materialize, as when Nemsa and Yusufan did not get approval to operate, they continued as if the business was owned by Bahamian. So this was a breach of the agreement. So counsel also submit that with regard to the violation of Bahamian law by Nemsa and Yusufan, and then he's listed exchange control again, the business license, central bank, immigration, NIB, VAT. He went through all of those again. So he said, with respect to the central bank approval, ZRK submits that NEMS never received approval to operate a Bahamian dollar account in accordance with Regulation 8 of Exchange Control. They also say that no work permits were issued to NEMSA and Yusufan or to the person that they brought in from outside the country to work. Contraventions of the NIB and the VAT, no contributions were being made and no revenue was being forwarded to the authorities from sales in the cosmetic store on Bay Street. ZRK accuses NEMSA and Yusufan of bypassing the system, which would have recorded the sales amount so that there would not be a record of them. As such, ZRK put an end to the lease to avoid personal liability of its directors with the National Insurance Board in particular. There was no breach on the part of ZRK, and further, no negligence was pleaded on the part of NEMSA and Yusufan. So NEMSA and Yusufan said that it was solely ZRK's responsibility to ensure all regulatory approvals were in place. ZRK was also responsible for the registration of the business with the Department of Inland Revenue. It was therefore ZRK that breached the agreement and or negligently failed to obtain the regulatory government approvals for the business, causing them to suffer loss and damage. So what you see is happening here between Yusufan and NEMSA versus ZRK, the company, and this management agreement that they have. What do you see is happening between the two of them? They're sitting there in court. One has a view and the other has a view. What's your view so far?
I'm confused.
Why are you confused?
I'm following.
So
The
this
different
is what
names
this
just
is. Okay.
ahead.
So this is what is happening. You had two foreigners who came here, wanted to start a business. They met these Bahamians and they decided that they would enter into an agreement where they would lease their property via these Bahamians' company called ZRK. ZRK and its directors knew that these two individuals did not have the requisite approvals to operate a business. They knew it from the beginning.
Hold on.
And they
Stella.
knew it what,
Okay, so the two separate businesses met Bahamians.
No, ZRK is one company that is owned by the Scandalaris.
Okay, that was my question. So you just answered my question. Okay.
Okay, right. So these two foreigners met with the Scandalaris and they came to an agreement where they would lease the Scandalaris property on Bay Street.
So the Scandalaris are the Bahamians?
Yes,
Okay.
they're Greek Bahamians.
They're Greeks. Mhm.
Okay.
Right. So they entered into agreement where they would lease the premises to these two gentlemen. These two gentlemen say that they are going to operate a cosmetic business. They got legal advice, which told them the process that they have to go through and all the approvals. The Scandalaris, via their company ZRK, said that the two Americans, or the American, whatever the next one is, that they didn't want to listen to what the lawyer had to say.
The Bahamian lawyer.
Yes,
Mhm.
that they had to go through all these approvals. And they're saying now, the Scandalaris, the Bahamians, that they went ahead, leased the building from them, renovated the building, brought in their products, operated their business, hired a bunch of foreigners. They say everything they passed was different foreigners, and they were not paying their taxes, which they were aware that they needed to do, because when they met and they were advised by their attorneys that they had to get all of these proper licensing in order to operate.
Okay.
So now that Scandalaris is saying that they haven't done all of these things, they haven't gotten none of these approvals, they need to vacate and give them 30 days to do so. And so now the two foreigners are suing ZRK, the company.
But I mean, okay, so was any of that in the agreement, the management agreement? That they would obtain these necessary approvals?
Okay, so let me see.
Because I mean, otherwise, what would stand in court? They may have discussed it verbally, but I mean, were these outlined in the management agreement that CRK would actually be, be responsible for obtaining these necessary approvals? If
Okay,
not, then what
so
would they stand on? Because I could tell Christine after anything, but then when it comes to court, it's my word against yours.
So according to this management agreement, it says outgoings. The operators are responsible for the payment of all outgoings and expenses that in any way relate to the employment of the employees, along with all taxes payable in conducting the business and rendering the services, including but not limited to national insurance, VAT, and custom duties. In order to facilitate the provision of the services, the owner hereby appoints the operators as his agents and representative with full power to do all things on behalf of the owner, which the owner could do in order to properly and effectively carry on the business. And these powers include, but not limited to, enter into contracts on the owner's behalf, accept and commit to obligation on the owner's behalf, pay any liability on behalf of the owner, accept payment from any person on behalf of the owner.
That still doesn't stipulate that they were responsible for obtaining the necessary approvals, though.
Okay, hold
They
on.
will pay it.
Hold
You will
on.
pay the fees.
Management, the operators must ensure at all times in providing the services that the business is well managed in accordance with good business practice, that all laws and regulations enforced at the time in the Commonwealth of Bahamas are complied with, and that proper complete records are kept in respect of all matters relating to compliance.
That is quite fine, but where is it that says CRK was to obtain these necessary approvals to make the company operation legit? I didn't hear anything, and I mean, it wasn't stipulated. Yes, it said to pay the fees and sign, but doesn't say to obtain.
Okay, so hold on. I can tell you what the judge said, trying to find it without giving you too many long cases. Because it's the last 4 pages. Okay, because he's going to talk about illegality. So the first case he gave,
this is his summation.
the judge.
The judgment.
This is what the plaintiff cases. So the plaintiff says, so the plaintiff is saying that's NEMSA. They're saying that ZRK has not proven its case and that the agreement is valid and subsisting. As such, it is capable of enforcement despite, as they submit, having a taint of illegality. They also submit ZRK willfully took advantage of NEMSA and Yusufin's ignorance of Bahamian law and would be unjustly enriched if the agreement is not enforced. So he then went to the definition of illegality. So the judge says illegality as per the author's treaty on contracts. It defines it as objects which on grounds of public policy invalidate contracts may for convenience be generally classified into 5 groups. First, objects which are illegal by common law or by legislation. Secondly, objects injurious to good government, either in the field of domestic or foreign affairs. Thirdly, objects which interfere with the proper working of the machinery of justice. Fourthly, objects injurious to marriage and morality. And fifthly, objects economically against the public interest. This classification is adopted primarily for ease of exposition. Certain cases do not fit clearly into any of these 5 categories. The enterprise engaged in is restricted to Bahamian ownership, no doubt, for at least the 5th above stated ground, that it is economically against the public interest. Further, in the same book, Treaty on Contracts, it says, neither party can sue upon a contract if A, both knew that its performance necessarily involved the commission of an act which, to their knowledge, is legally objectionable, that it is illegal or otherwise against public policy, or B, both knew that the contract is intended to be performed in a manner which, to their knowledge, is legally objectionable in that sense, or C, the purpose of the contract is legally objectionable and that purpose is shared by both parties, or D, both participate in performing the contract in a manner which they know to be legally objectionable. It is the unchallenged evidence that 1, wholesale and retail operations, 2, personal cosmetic beauty establishments are sectors reserved for Bahamians. NEMSA and Yousafzai themselves have accepted that the public policy in the Bahamas limits participation in retail business to Bahamians. They assert, however, that they did not know that they were operating illegally and had no intention to do so. Attorneys for NEMSA and Yousafzai submits, as per the case of Parking Eye, that this is merely a case of common law illegality. And then he went to expound on another case out of the UK called Patel versus Mirza. And he said the question to be asked are as follows. The essential rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. In assessing whether the public interest would be harmed in that way, it is necessary, A, to consider the underlying purpose of the prohibition, which has been transgressed, and whether that purpose will be enhanced by denial of the claim. And B, to consider any other relevant public policy on which the denial of the claim may have an impact. And C, to consider whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. So he says, respectively, the primary object of the agreement was to permit the plaintiffs to own and operate a business in the Bahamas, which, but for the cloak and dagger of ZRK, they would be unable to do so. The business license states that it was granted to ZRK Limited as Drufari on the 12th of August, 2016. The agreement entered into by the parties is oft described in the Bahamian vernacular as a, quote, fronting operation, end quote. Simply put, Nemsa and Yusufan were the true owners of the cosmetic business, with a fee to be paid to ZRK to act as the Bahamian owners. Clause 1.1 of the agreement states that the operators, that is, Nemsa and Yusufan, were to receive 100% of the profit from the business. I am not convinced that Yusufan and Nemsa were ignorant that their actions and that opening and operating a business in the Bahamas without the requisite approvals and licenses was an innocent venture. Nemsa and Yusufan never had any status in the country outside that of a visitor. Yet they were, quote, managing the business of ZRK. In addition, the evidence reflects that Nemsa and Yusufan sought legal counsel, and there was never any evidence proffered that the advice was deficient relative to the requirements to engage in the cosmetic business as non-Bahamians. The illegality was a major part of the agreement and not merely peripheral. But for the agreement, the business would not materialize. At some point, the directors of ZRK realized that simply speaking with Yusufan and Nemsa about the non-payment of national insurance benefits, VAT, and other concerns was not inspiring Nemsa and Yusufan to resolve any of the issues raised. However, this brings me to the submission of counsel for Nemsa and Yusufan regarding common law and statutory illegality. On balance, I find it difficult to accept that Yusufan and Nemsa did not have the requisite knowledge that the contract that they entered into with ZRK may have put them in contravention of Bahamian public policy, and at the very least, Bahamian immigration law. These were men who entered the country with visitor status and started a business on which they needed to operate through Bahamians to carry out. It appears that the agreement between the parties was used to facilitate the circumvention of a widely known public policy in this country, that retail business in cosmetics is reserved for Bahamians. I am satisfied that this is not merely a public policy issue by a statutory illegality, as the true owners of the business are not reflected on the business license. If that had been properly reflected in the application, there would likely have been no license issued. Additionally, the venture appears to have been operated in contravention of various laws relating to immigration, national insurance, and VAT. Agreements such as the agreement entered into by Nemsa and Yusufan and ZRK is to be avoided. Having regard to my decision that the agreement is invalid, it is otherwise unenforceable. There shall be no recovery for loss of business, loss of income, or the refund of rent as claimed by Yusufan and Nemsa. The principle of the loss lying where it falls is applicable. Yusufan and Nemsa have brought no claims for unjust enrichment as were pursued in Patel, the case of Patel. I will grant only the claim for Yusufan and Nemsa's security deposit to be returned, as this payment was clearly akin to the landlord and tenant aspect of the relationship and not the unlawful business venture. While the agreement is invalid, ZRK's decision to avoid being further embroiled in violations of the law by evicting Nemsa and Yusufan was nonetheless reasonable in the circumstances. However, ZRK's involvement in the creation of the invalid agreement cannot be denied or ignored. It likewise cannot, having regard to its part in the illegality pursue claims against NEMSA and Yusufen. And then he said, the counterclaim by ZRK is dismissed. Everybody had to pay their own costs. Any comments?
I got it in the end. The Bahamian company.
ZRK,
Yeah, I think it was fair because you knew what you was doing from the break.
it was illegal.
Yes, and I heard the term fronting the business. And
Yeah.
also he did like admit that passing, he would see new people and he'll ask about it, but you never disclose it knowing that it's illegal.
But you were part of the whole thing, because why would you enter into agreement if he doesn't have the requisite licenses? It's illegal.
Yeah, because he need that $500 a month.
Exactly. He knew he was fronting.
Yes, he knew. So
He
you
knew-
just have to
yes,
take
he
it.
knew.
Yes, he knew. And like you said, somewhere in the end where you mentioned the wrong owners were on the business license. So those other guys wouldn't have gotten the business license because of
They're foreigners.
legal work. Yes, and they came in as guests. But you work in.
Mhm.
And
And
you
the
bring
thing
in
is
other
that-
people to work.
And there were still visitors.
Yes.
There were still visitors.
One question where I got lost.
Okay,
The
go ahead.
directors, who are the directors? The directors are who?
Candelaris.
And who's that? The Bahamians or the
Yes,
foreigners?
they're the Greek Bahamians.
So the directors are the same people who collecting this 5,000 a month?
Yes.
Okay. I was
Don't
listening.
forget that.
that-
It's a
I
company.
understand where you was coming from, but the different weird names, it was like a Johnson.
Yeah.
The
I'm
different
gonna
weird
send it.
names
I'm gonna
keep on-
send. Yeah, I'm gonna send it to you all.
Yeah, the names are what got me confused because I wouldn't remember who ZRK and then you come back. But when you kept on saying
Yeah.
the Bahamians, that's when I was able to keep track because of the names.
Right. So ZRK Limited is the Scandalaris, the Greeks. You remember where Scans was on Bay Street?
Mhm.
Okay, right there.
Headed east on the left.
That would be on the
And-
north. If you're on Bay Street, which goes east, that would be on the northern side, right after the straw market.
Yes, on the left. That's why I say on the left, right?
Yeah,
Yeah,
the
sitting on the
left.
corner.
Yeah.
Sitting on the corner. Yeah. I remember. Yeah, you know what? I've been on Bay Street some years ago and I remember some
Yeah,
foreigners
cafeteria.
walking out trying to give you some gold, something for your face or some mess like that.
That's it. I
Yeah.
think they opened 3 stores on Bay
Yeah,
Street.
it was some years ago. They outside with the. So
Yes.
aren't there isn't there a charge for like you knowing that illegal people working and you said nothing?
They were getting paid. Then they got scared,
Yeah, but why are you talking about it now? Because we know you know about that long time.
but you got scared. But they had no choice because the 2 foreigners brought them to court.
I don't think that case
Foreigners
went
take it
fairly. I
on.
don't think that was a fair case. I mean, in
Why?
my opinion. Because I mean, like, I feel like the Greeks, I feel like the Greeks really, really was responsible for this whole downfall of the business venture because they were actually, like I say again, they actually they were fronting. I mean, like a lot of fraud issues came out of that. And like I said, they are businessmen and they ought to have known what was required to operate this business. And I feel like they misled the 2 owners. I feel like they misled them, because they had them under the belief that they were operating this business legally and they were not. They knew what was required to actually operate in what was required, in legal terms to operate this business. And they didn't carry out those actions or, So I
Mhm.
feel like the 2 owners had a very good case against them, but of course, sound like somebody get paid off. I hate to say it like that, but I don't feel like the judgment was fair.
Why?
Because of what I just said, I just feel like they were the
Yeah,
Greeks
I
are
think so too.
the reasons this whole thing fell through. they misled the two owners.
Yeah,
I
but
feel like they
remember,
did some swinging in there. They knew they
Yes.
were
Yeah, but-
wrong. They did some extra swinging to probably, make some malicious lies in between to make it seem as if you don't have to do this, man. You know how people go. X, Y,
Right.
Z. And then it kind of gave the other guys some comfort that certain things didn't have to happen. And I feel like they
Right.
did that just so they could gain what they need to gain on their end.
Yeah, that's right. That's right. They misled those two individuals, and I'm sure if they had told them outright exactly what was required, they would have gone ahead with it, whether they had to pay it or not, and they were willing to pay. It's just that the Greeks didn't go follow through and actually obtain what was necessary.
but hold on now,
But
Don't forget now, they had a lawyer who
Please.
told them what was required.
Yes, but the Greeks told them not to listen to that, right?
Nah, they didn't say that.
I mean, what they said was, I mean, in so many words, it's not true. You don't need all those things.
Oh, don't worry about it.
Right. Right. So then don't worry about it. Whereas at the same time, you know that you need to go, you need to get a business license, you need to go and get a VAT certificate, you need to go and register with national insurance. You know these things. It's been around for a while.
So,
So
so
why did
my
you go to
question
get-
is, yeah, but my question now is, which lawyer drew up this contract?
Okay, then. Did they say?
No.
Probably no lawyer. That's it right there.
Because the first thing is that you come to me for me to draw up a contract for something that you know requires certain approvals.
Thank you.
So this is the same way like when I say you have an FCSP, you're the first and the person is just land in the Bahamas. They
Mhm.
want to get permanent residency. They want to buy a house or piece of property so they can qualify. You are the gatekeeper.
Mhm.
So they met these two foreigners. They want to open a business. They were the gatekeeper.
Mhm.
They want to come here and do business. You tell them right off the front, okay, you want to do this business, only Bahamians are allowed to do that. Everybody knows there's a list of businesses. If you
Okay.
didn't know, your lawyer would have picked up the phone and say, we have some foreigners who want to do business with Bahamians to do cosmetic business. What are the requirements? What needs to be done?
Right.
So why would you draw up a contract for a business that you know requires approvals?
Right. And that was not in the contract. So that's why I feel that the judgment was not fair. On the
Well,
part.
they could have gotten back their money if they had pleaded for unjust enrichment. They didn't.
Right. It all depends on how the case was presented.
You're right. They did not plead for unjust enrichment.
But they had a solid case.
They had a good case, yes. And
Mhm.
because they didn't plead for it, they couldn't get it.
Get
So
it.
they lost.
Yeah, that's what it is.
And again, that's going to hurt the reputation because depends on if they're not that wealthy, then they're going to be all about promoting about the Bahamas and how they were used and this person caused them to break the laws and all that kind of stuff. But
Rightfully so.
their lawyer didn't plead for them to get, they stated these were their losses, but it wasn't pleaded.
That's unfortunate.
Yeah. It was.
Wow. We have
So
some
I thought
trips
this
over
was,
here,
but
boy.
when I read this case, the little synopsis in the paper, I had to wait for this to be posted. And I said, this is a very good case for company law.
Mhm.
Yes, let
A
me
lot
just
of
ask you, by the
bridges.
time this class is over, I don't have to send these emails to Higgs and Johnson. Is he trying to turn me into a lawyer?
No, I am not. I just trying to make you how it is applied in real life. See, because when you read company law, you're reading it, but you got to be able to see how people use companies for different purposes.
Mhm.
And then to make sure that they're not liable individually, the Scandalaris use a company.
Yes.
They entered the contract in their company. So even though they spoke to them one-on-one, met them in in public, had discussions, the contract was entered in the name of their company. And so the company was the owner of the property. They only acted as directors. So John Scandalaris is one of the directors who gave evidence in court. So that's how people, a lot of people, when you hear them, it's like, I think it is. Was it Friday when they spoke about the new airport in Grand Bahama? And then they give you the names of the parties, a Bahamian company, a foreign management company, a foreign development company, all of these things. You have to look at how these companies are being used and how they're being structured. That these companies, they be used not just for against public policy, but they're being used for corruption. They're being used for bribes, trafficking, money laundering.
Well, I even wonder if the company owned by the Greeks was a legit company. I mean,
You mean
that's
in its,
questionable.
you mean in its original stance?
Mhm.
Well, don't forget now, they had already contracted to move into Bahama.
Under that same company name?
Under the, I don't know if it's going to be used under the old name, but this is before it became Bahama, remember?
No, I mean the Greeks business what was the name?
ZRK.
Right, ZRK, is that a legit business?
It probably was. They were on Bay Street for a very long time.
Okay.
But don't I was saying that, don't forget now, they were part of those businesses that had already put their businesses, closed down their businesses to move into Ismailian new hotel.
Mm-hmm.
And that fell through with the Chinese.
Mm-hmm.
So a lot of those companies lost money there.
Mm-hmm.
So I guess they're trying to recoup their funds.
Right. So
By
that whole deal
right.
was a thing,
Yeah,
pretty much.
yeah. So they might have been desperate to try to see how they could recoup some funds
Mm-hmm.
since that loss. So
I
it
still
happened.
feel like the government entity should go after the Greeks and make them pay.
Oh, that'll be on the criminal side now. But the thing is
Right.
that it was illegal itself. But you notice the part that the part with the bank account, that part stood out to me too. Like the bank accounts appeared to have been in the name of ZRK,
Mm-hmm.
the First Caribbean bank account. That part was kind of,
Isn't ZRK the foreigners?
no, ZRK is the Bahamian company, the Scandalaris.
Right.
But you have to say Scandalars, because that's the only thing I can remember.
Yeah, they were saying something about an account at First Caribbean. And I'm wondering
If this
if,
account was under the Scandalaris.
yeah, that's what I was trying to figure out.
I remember you mentioned First Caribbean, because at that point I was like, how do foreigners open up account? They the KYC to present to
And
open
they,
that.
and the thing is, and they didn't have exchange control approval to open that account, but it says here that they lost $60,000 held on First Caribbean bank account. So how did they lose money at the bank?
Well, it all depends on who the signatories on the account.
Okay, so hold on. So NEMSA and Yosefin, they claim they wanted an injunction preventing the Scandalaris from accessing the funds at First Caribbean. So that means that the funds was in the name of CRK.
Okay, or the Scandalaris were signatories on the account. But I mean, can foreigners open accounts in
So I was
the,
gonna ask, no,
Not a $B account.
did it state that it wasn't?
yes, I heard a state $B account.
It says
I heard-
$B. It says $B.
Okay,
Loss of funds totaling $B. The B is there,
right, okay,
60,000.
okay.
Because remember, it did say that they did not failing to obtain approval from the central bank. Exchange control,
Mhm. So the account was open in the name of,
ZRK,
Okay.
Scandalaris.
mhm,
So it's fronting no matter how you look at it.
yeah.
It's fronting.
Mhm.
See, clause 22 says, with respect to the central bank approval, ZRK submits that NEMSA and Yosefin never receive approval to operate a Bahamian dollar account in accordance with regulations 8 of the exchange control. And they also say no work permits were issued. So anyhow,
Hmm.
That's- yeah.
Oh, close.
mhm. So it is right there. It was in their name. There's violations upon, but how did he? Oh, it's in CRK, so they could open a $B account.
Mhm.
They could.
Well, they have to account for where the money's went. I mean, very easy to do.
Mm-hmm. But from the reputational standpoint, this is not a good case.
No,
This was
even on
not a
the
good,
part of, even on the part of First Caribbean.
yeah. But they wouldn't have known. It depends on how ZRK deposited those funds. No, but then Yusuf Fund then probably deposited the funds into the account.
Mhm.
How that work? Hmm.
Well, they would have had to,
Listen, that's First
every time
Caribbean.
do a source of funds.
Somebody
Yeah.
knows somebody and somebody is making sure the job get done.
Yeah,
Easy as that. And then that's probably First Caribbean right downtown, right there. So everybody is familiar with everybody.
Mm-hmm.
So they just was doing whatever for somebody and they probably got some monies to do it. So they did it.
Mm-hmm.
That's exactly what happened. They just didn't include that part in the case.
Hmm. As you think about it more, you can think of a lot of loopholes,
mhm.
a lot of things that this should not. Because I kept saying, where these people coming from?
I think the FIU really need to look more closely at that whole setup.
I kept saying, where these people come from? Why are they selling this here? That whole thing could have been a front.
Mhm.
They could not have been selling cosmetics. I keep saying they must be selling something else.
Was it a brand name?
It was some weird gold thing. It's like a gold,
What do you call it? Trufory.
yeah, like
I
they just
never-
gold
see.
mask and foolishness.
I didn't look at,
remember.
Oh,
let me look up the name. Let's see what we find. Here, Google. Let me see. TRUOIRE.
That wasn't the place that sold the Bobby Browning.
What is
No,
it?
no, that's John Bull.
No, yeah, that's John Bull.
Okay.
Truffaut is experience indulgent skincare from truffles infused with beneficial vitamins and minerals. Anti-aging.
Mm,
Yeah, they have some gold mask thing. I can remember it. I was like, what?
Yeah, let me see. Yeah, Truffaut. I see. It's a luxury brand.
oh,
Yeah, committed to
Yeah,
provide the
no.
highest.
The mask
Yeah.
is a gold thing because I remember the guy coming out telling me something. I don't know what he's talking about.
Yeah, me too.
you all
I
tried
don't.
it?
I
No,
never.
I
No,
didn't
I
try
never.
it. I was going to
I-
Starbucks and he came out with the thing, and I remember it being like a solid gold, thick color, and he was telling me something about it being a mask or something of the sort. But in
Mhm.
my mind, I'm like, that's for white people. Don't fool with me.
Right.
Okay, so this question say, why is it
So
so
it was something
expensive?
high end and expensive.
So the ingredients in all of Truffaut's product contain only the richest that the brand can find, and most of these are rare and hard to come by. Truffles, for example, they are the rarest and most expensive because it takes years to cultivate in a specific habitat and are highly seasonal. Mm.
So they were made from like really, really raw products.
Yeah, so in our opinion, there's a review. Truffaut products aren't worth the money simply because there are other skincare brands that offer similar products. So it really is for wrinkles.
Oh,
Mm-hmm. But I don't think they were selling that.
You never
Mhm.
know.
Yeah, it's something
Maybe
else.
some other stuff, yes, ma'am.
Yeah, has to be for something else. So that was a good case.
It was.
So I want to send that to you all, so you know that will be on the exam.
Man, listen, I read nothing else. I going off what you just said. I just need to remember the names, but I going off with that.
You don't have to remember the name. All you know it was the Bahamian company
mhm.
on Bay
as
Street.
foreigners.
Yeah, I don't have to read that. I remember because if I go and read it, I might get confused. So I'm gonna stick with what I got from you.
So-
No, I do understand the case.
Mhm.
As a matter of fact, I understand all the cases that were read by you and not the ones read by me, because when I read them, my brain just be all over the place. And
Yeah,
they're so
yeah, you did
long
say that.
sometimes. They're long, and then the Bahamian cases, the lawyers would consistently repeat a certain section as I go, and it
Mhm.
caused me to get confused. But I feel like when you read it, because you kind of summarize it, I gather all the information better.
Okay.
I think this one was easy to follow too.
Mhm.
This one and the one with the husband and wife.
Oh God, y'all like the husband and wife too?
We love that. So put that on there.
Did
I
you
have
do
all the
the
information
FR
for
one?
that.
And what about the one with the diving?
For sure, that was mine. That was initially mine, and I got lost. But yes, I will never forget that one. Yeah, I understand that one clearly,
Yeah, they lost
because that one
everything.
is it's not like this one that you just read, but
Mhm.
it was a case where they should have appealed it in Miami.
Yes.
That's like this one that you just read. Had they
Mhm.
go a different route, they may have won. And
Yes.
just like the other one for the divers, had they appealed it in Miami, they would have had a better chance than just leaving it be,
Mhm.
knowing that there were summons.
Yeah, they could have still been in business.
Yes, ma'am.
Mhm.
I tell you, once you read it, I know what's happening. If I have to read it, Lord help me.
Yeah. So that's it. We'll do liquidation. I think I have a case for next class too. It's not as juicy as those.
Is it a liquidation case?
It's a striking off. I have quite a few liquidation cases though, but I find it may be a little difficult.
Yeah, don't give us no difficult one. I just took up a
Yeah,
company
to
for the first time
understand.
a couple weeks ago. I didn't
Yeah,
even
maybe a
know
little
how to-
difficult for you to understand, so I don't want to make it too complicated. If
No,
I
ma'am.
find one that's kind of simple, I'll see. but I have one on striking off and restoration.
Yeah, let's go with the striking off. Because I
Yeah.
just learned that, let's see, 3 weeks ago.
All right, so I'll send this case to you all so you can read this one.
Mm-hmm.
It's a striking off one?
I'll send the striking off one and this, the one I just read, ZRK.
CRK.
Okay.
Mhm. All right.
Okay,
All right.
Okay.
So have a great weekend and
Thank
be
you.
prepared next week.
you too.
Yes.
We'll do the review.
Caroline,
Okay.
Okay.
Caroline, don't forget the capstone now.
No, I
Oh,
saw
no,
that.
no.
So we had a change and how it's, and
No, we're not no change. I just reminded
No
you.
change.
oh, no, but I saw, something was sent out yesterday.
Yes, remember, okay, if you weren't in class last week, remember, the question was asking that it was so, when they look at the link, they didn't know like what exactly, which one do I want you to use? So what I did was I sent you the 3 model articles.
Mm-hmm.
You can choose any one you want. And then I said, look at our table 8. You could decide which sections you think need to be modernized, and then look at what I sent you. You can pick either a public company, limited by shares or by guarantee, or a private company, and use that as your comparison, and just tell me where you think amendments need to be made. There's no rocket science. There's no digging up further.
Oh,
I
okay.
you
So
to
that's
see-
the capstone. That's what we need to do now.
Yeah, for that first question. And then just above that, I put the latest amendment, which was the Mental Health Discrimination Act.
Mhm.
You know, it says under common law that a director, once his mind is gone, that's it. He has
Right.
to be removed. And so in the UK, they have done some amendments to their Mental Health Act. Because discrimination is everything now. Discrimination, how you walk, how you sing, how you eat, how you dress.
Everything.
This is mental discrimination. So look at that and see, maybe that is something that we should consider.
Okay.
So it's only just looking at trying to modernize our legislation.
Okay.
That's all. This is no writing no 15 and 100 pages or nothing. No. Looking at the UK, because they've modernized theirs over time, and just seeing where we need to modernize ours. And let's give a rationale as to why you think we should.
Okay.
All right?
Turned in before the 16th, so by the 16th.
Yeah, on the
15th.
day of the exam.
Mm-hmm. Okay.
Okay?
All
All
right.
right. So we will chat. Our last class is next week.
Yes, ma'am.
I'll hear from you all then.
Okay, have a great day.
Okay. Y'all take care. Be
All
safe.
right.
Okay.
Bye-bye.
Bye-bye.